This is a time date set excuse me, on hearing, set for hearing on non-party Melaleuca's motion for a protective order. Excuse me. I've reviewed the motions and the briefs. So this is your motion, Mr. Law. Go ahead.
Okay. Thank you, Your Honor. May it please the Court. Andrew Law on behalf of non-party Melaleuca Incorporated. We're here today, Your Honor, because plaintiffs have not been careful in how they pursued their garnishment efforts in this case. First, plaintiff did not carefully ensure that its garnishment documents accurately named a Melaleuca employee as the judgment debtor. Second, after Melaleuca's garnishment answer was filed with the Court, plaintiff did not carefully accept, to deny, or otherwise controvert any part of Melaleuca's garnishment answer within 3 days after the garnishment answer was filed with the Court. Plaintiff likewise did not seek an extension of time in order to controvert Melaleuca's garnishment answer, and as a result of plaintiff's failure to object to or seek more time to object to Melaleuca's garnishment answer, that garnishment answer became true and sufficient under Idaho Code Section 11722, and under that statute, discharge of Melaleuca from all liability is appropriate. Rather than accept Melaleuca's garnishment answer, rather than accept it had become true and sufficient, plaintiff simply propounded additional discovery on Melaleuca, and that discovery is squarely intended to challenge Melaleuca's garnishment answer. Third, moving forward and even ignoring the roadblock that is Section 11722, plaintiff's discovery was not carefully formulated. Specifically, plaintiff propounded unreasonably cumulative and duplicative discovery, and discovery that is available from a more convenient and less burdensome source. Finally, plaintiff has not been careful in considering Melaleuca's offer to resolve this matter short of this motion and hearing. Specifically, Melaleuca invited plaintiff to propose a solution that is less burdensome than a notice and deposition and a subpoena to produce documents. That solution could have consisted of a simple discovery request, but plaintiff chose not to take Melaleuca up on that invitation. And because plaintiff has not been careful in pursuing its collection efforts in this case, good cause exists to enter a protective order and to quash the plaintiff's notice and subpoena. And, Your Honor, it's important to make clear here that Melaleuca is not being hypercritical of plaintiff. Melaleuca has helped plaintiff by garnishing the wages of its employees on many, many occasions. And it's, Melaleuca has a responsibility to protect its employees, and so it's pushing back here where the garnishment documents don't accurately identify a Melaleuca employee. Melaleuca simply can't guess at who the judgment debtor is, and it doesn't bear the burden of doing so under the Idaho Code. And because it is inevitable that plaintiff will submit additional garnishment documents, Melaleuca must push back where plaintiff has not been careful in order to protect itself and to protect its employees from wrongful garnishments. In short, there are numerous reasons to enter Melaleuca's proposed protective order and to quash the notice and subpoena. I'd like to first turn to plaintiff's failure to carefully prepare its garnishment documents and its failure to object to Melaleuca's garnishment answer. The Idaho Supreme Court has made clear that creditors are supposed to know the names of their debtors, and that in attempting to collect on a debt, creditors risk, quote, suffering the penalty of their own negligence, close quote, for failing to properly name a judgment debtor. And because Melaleuca had no record of employing the named judgment debtor, it responded accurately that it doesn't have any money or property in its possession or under its control belonging to the named judgment debtor in case number 2018-33. But as a show of good faith, to accommodate plaintiffs and to help them evaluate the accuracy of their records, plaintiff identified that the Social Security number found in one of the garnishment documents matched the Social Security number of one of Melaleuca's employees. Melaleuca made clear, however, that it had no knowledge that its employee was in fact the judgment debtor. And Melaleuca also made clear that it could not resolve any discrepancy in plaintiff's records as to the identity of the judgment debtor. Melaleuca's garnishment answer was filed with the court on May 3rd, 2018, and if plaintiff was dissatisfied with the garnishment answer, that is, if plaintiff believed that Melaleuca actually did employ the judgment debtor, plaintiff should at that time have accepted to or denied or otherwise objected to Melaleuca's garnishment answer pursuant to the garnishment statute, that is, within 3 days after Melaleuca's garnishment answer being filed with the court. Plaintiff failed to do so, and as a result, under Idaho Code 11722, Melaleuca's garnishment answer became true and sufficient as a matter of law. And because plaintiff failed to controvert Melaleuca's denial of liability in its garnishment answer, Section 11722 also requires that Melaleuca be discharged from all liability at the cost of the judgment creditor. I'd like to talk a little bit about what it means to be true and sufficient. That Melaleuca's garnishment answer is true means that it is a factual statement. That is, by law, it is a fact that Melaleuca does not have any money or property belonging to the named judgment debtor. By law, it is a fact that Melaleuca has no knowledge that its employee with the same Social Security number is in fact the judgment debtor. And it's also a fact that Melaleuca cannot resolve any discrepancy in plaintiff's records. And that the garnishment answer is sufficient necessarily means that it is adequate, complete, it's enough for the purposes of these garnishment proceedings. Plaintiff's discovery, its notice and subpoena, disregard that Melaleuca's garnishment answer is now true and sufficient. Indeed, plaintiff seeks to test Melaleuca's garnishment answer, especially the statement that Melaleuca has no money or property belonging to the judgment debtor. Specifically, in its opposition, plaintiff states that, quote, based upon Melaleuca's answer to garnishment, there is substantial reason to believe that Melaleuca has under its control credits and or personal property of the judgment defendant. But if plaintiff wanted to test Melaleuca's garnishment answer and whether Melaleuca did in fact have credits of the judgment debtor, it should have tested that answer by accepting to it or denying it as provided for in the garnishment statute. But again, plaintiff failed to do so, and plaintiff cannot now make an end run around the garnishment statute by propounding general discovery in this matter. Given that plaintiff seeks to challenge Melaleuca's garnishment answer, an answer that is now adequate, accurate, and complete, good cause exists to prohibit further discovery of Melaleuca based on the operation of Idaho Code 11722. Moreover, because Melaleuca has already made clear that it has no information about the named judgment debtor, requiring it to send an employee to a deposition to respond to a document subpoena necessarily constitutes an annoyance, suppression, or undue burden under Rule 26C1, and it is unreasonable, oppressive, or subjects Melaleuca to an undue burden under Rule 45D1. Plaintiffs argue that they have a specific legal entitlement under Idaho Code 11717 to more discovery in this case, but that is simply not accurate. Section 11717 provides for examination of a garnishee, including a corporate garnishee, quote, owing debts to the judgment debtor, or having in its possession or under its control any credits or other personal property belonging to the judgment debtor. But as Melaleuca has explained, and as is now a fact by operation of Idaho Code 11722, and as a practical matter, that Melaleuca does not have under its control any money or property belonging to the named judgment debtor is established. As a result, Idaho Code 11717 provides no specific legal entitlement for plaintiff to take additional discovery of Melaleuca. Your Honor, it's also important to make clear at this point that it is not premature to enter a protective order that discharges Melaleuca from liability. This is so because it is plain that plaintiff intends to pursue Melaleuca for the underlying debt in this case. Indeed, plaintiff has already demanded money from Melaleuca in its May 18, 2018 letter. And plaintiff has not, as far as Melaleuca is aware, sought discovery from any other source. It's only focused on Melaleuca here. And plaintiff uses qualified language in its opposition that plainly suggests that it is going after Melaleuca. For example, plaintiff states that it is not, quote, currently seeking to hold Melaleuca liable, close quote. Plaintiff also says that, quote, at this point, plaintiff is not exempting or denying Melaleuca's answer, indicating that it will soon. In short, while plaintiffs have made clear that while it hasn't pulled the trigger yet, Melaleuca is certainly in plaintiff's crosshairs. And because Melaleuca is plaintiff's target here for the underlying debt, it is proper that the court apply Idaho Code 11722 to discharge Melaleuca from liability. Moving forward, plaintiff's nota and subpoena should also be prohibited under the mandatory language of Rule 26B1Cii, which requires that the court limit discovery that is, quote, unreasonably cumulative or duplicative, or can be obtained from some other source that is more convenient, less burdensome, or less expensive. Here, plaintiff's discovery seeks information about the employment and payroll history of, quote, Brianna Huerta, also identified by her Social Security number, close quote, ending in 6517. Plaintiff does not seek discovery about Brianna Huerta and or any Melaleuca employee that has the Social Security number ending in 6517. In other words, plaintiff's notice and subpoena can only be interpreted as seeking discovery of a, but again, as Melaleuca has made clear, and as is now an unassailable fact, Melaleuca does not employ someone with the name and the Social Security number ending in. Thus, if Melaleuca sent someone to the deposition, that person would have no information to provide and no documents to bring regarding with the Social Security number. Plaintiff's discovery is unreasonably cumulative and duplicative and ultimately futile and should be quashed under Rule 26B1Cii. And importantly, plaintiff has made no argument otherwise in its opposition. Additionally, assuming the plaintiff's discovery is aimed at learning the true identity of the judgment debtor, despite not actually saying so, plaintiff has not sought discovery from the best source of information, the judgment debtor herself. Melaleuca cannot definitively answer plaintiff's queries as to the true identity of the judgment debtor, and plaintiff has not argued at any point up until just a few moments ago that it is impossible to seek discovery of the judgment debtor herself. And because there is a more convenient, less burdensome source, and ultimately a much more reliable source, the judgment debtor herself, plaintiff's discovery must be quashed under Rule 26B1Cii. In conclusion, Your Honor, plaintiff's failure to carefully prepare its garnishment documents, to object to Melaleuca's garnishment answer in a timely fashion, to carefully propound discovery, and to carefully consider Melaleuca's invitation to find a simple, efficient solution to this dispute, provide good cause to enter Melaleuca's proposed protective order and to quash the notice and subpoena. And unless the court has any questions, I'll reserve my time.
Thank you. Go ahead, Mr. Smith.
Thank you, Ron. So, what we have here, Your Honor, is a misunderstanding by Melaleuca, and it may be because they don't do this kind of work. I can understand that. Few people do it. They completely get the statutes wrong, and I'll show the court how that's the case. I don't blame them. I don't talk about their negligent work not doing it right. They just don't have the statutes right. So what happens is, and I will let the court know that Mr. Zollinger sits on the Judicial Rules Committee. This last year we were able to get some of the garnishment statutes, in fact all of them, moved. They used to be in Section 8, 509, etc., and they were in Section 11. So now they all appear in Section 11. It took us 3 years to get them to do that, so we didn't have to hunt them around because they've been created over the years. They are now in Section 11. And let me just tell the court that originally these statutes appeared in Section 8, and they were enacted in the late 1800s. They've been around a long, long time. So if the court, I don't know if the court has the rules, these rules in front of it by any chance?
Yes, I do.
Okay. 11.719.
The rule or the statute?
The statute, I'm sorry. 11.719 deals with the case where the garnishee doesn't respond at all. That's usually what happens, is the garnishee just doesn't respond. And in that case, it's a bad statute. It says you can go after the garnishee by default. You don't have to serve anything on him. It's messed up. But the point is that 11.719 in the statute deals with the issue when the garnishee doesn't respond. The rest of the statutes in that code section, 720, 721, 722, and 723, all deal with the issue in this case, and that is, what do you do when the garnishee responds, but you're not buying the response? Okay. What happened in this case was, and I don't know how it happened, but there was a miscommunication in my office. They sent the letter believing this was an 11-7-19 case. So they did get a letter saying, hey, look, we may challenge this. Do you really want to go down this path? But in fact, we only do that for 11-7-19 when they don't respond at all. We've only had one other case in the history of the business that we do where somebody has responded saying we're not going to pay you. I think that's why there was miscommunication, because it just never happens. But under 11-7-20 through 11-7-23, those are the code sections that lay out the procedure on what a creditor would do if they get a response that they don't like. They think, yeah, they're not giving us everything, and these code sections, together with section 11-7-15, will impose liability on the garnishee. What that requires is that within 3 days of the word's kind of strange, 3 days after the filing, well, the sheriff gets it and never files it, so we're not sure what that...
Never files the answer?
Yes, unless the court's got it.
I've got it. It's
Okay.
on May 3rd. It shows like a file stamp on it from the sheriff's office.
Okay.
I always get those.
Okay. But in any event, you've got 3 days after its filing. I guess what I'm talking about is it's hard to say whether it's filed with the sheriff or filed with the court, but it doesn't really matter. The point is, we never did invoke code section 11-20 through 11-23. We never did challenge. So if the court looks at 11-21, for example, it says the judgment creditor may deny the answer of the garnishee and allege especially the grounds upon which a recovery is sought against the garnishee. And the issue presented by the denial, they can file a reply, and it shall be tried as ordinary issues between the judgment creditor and the judgment debtor. If the court looks at 11-7-23, the judgment creditor may move the court out of which the writ issued on or before the return day thereof for judgment against the garnishee for the amount of such admitted debt. The point is, we never invoked that procedure. Didn't happen. So all the arguments that they're raising, how we're like collaterally estopped or judicial estoppel or something to that effect, this has been litigated, it's finished, it's completed as a matter of law. Absolutely bogus. We never did invoke that procedure. We looked at their response and we said, well, we've already gotten the best information we can from her. She says that's her name. We also have a social security number. And so we sent it over to them, and it's not going to do us any good to talk to her again. She may give us yet another name. So instead of invoking this procedure where we could be held liable for costs, or they might be held liable for costs and attorney's fees, we are invoking another procedure. They keep saying the other procedure we're invoking is further discovery. In fact, he said it today. He said additional discovery, more discovery. We haven't conducted any discovery with Melaleuca on this issue. We simply did a garnishment procedure. They responded. That's not discovery.
But I have a notice of deposition from you.
That's correct. What I'm saying is, up to the point of that notice of deposition, there hasn't been any discovery to them. In other words, the writ procedure is not discovery.
Right.
They are calling 11-7-20 through 11-7-23 discovery procedures. That's not true. Those are execution procedures. So back in 1881, we got Idaho Code Section enacted 11-7-17. Okay?
Which you said doesn't apply here.
No, he said it didn't apply. I never said that. No, it could apply, because here's what it is.
I thought you said that you sent the wrong answer under 11-717.
No, 11-7-19.
That you accidentally sent that.
Yeah, so let's be clear about this.
Okay.
Under 11-7-19, that code section provides the procedure if a garnishee does not respond at all. Okay? We have a procedure for that because we get that quite a bit. The rest of the code sections, 11-7-20 through 11-7-23, those are the procedures when they respond, but you don't think it's an adequate response. We never filed anything, a motion, a complaint, a petition. We never served it on them. There's never been at issue. They never filed a reply. It's never been tried. So those procedures don't apply. We sent a letter in response to what we thought was 11-7-19, but that's not the same as 11-7-21 through 11-7-23. you actually have to file something challenging. It says right there in 11.721, the judgment creditor may deny the answer of the garnishee and allege specifically the grounds upon which a recovery is sought against the garnishee. We're not seeking a recovery against Melaleuca. We haven't filed that. We aren't invoking those. And that is 90% of their argument today is, oh, you guys are bound by having not objected within 3 days. Okay, as to that writ that we served on them, we're done with that. Water under the bridge. We'll take that as sufficient or whatever it is for that procedure. We're not seeking any liability against Melaleuca for that writ.
So then how do you have any authority to seek anything from them?
Okay, that's what I'm getting to right now. Okay, under 11.717, it says any person owing debts to the judgment debtor. Okay, what we know from their response is that they have an employee with the Social Security number. We believe the Social Security number is accurate. All right? If that's accurate, that means we now believe that there is a person, meaning Melaleuca, that owes money to the judgment debtor, meaning wages, or having in his possession or control any credits or other personal property belonging to the judgment debtor. We think Melaleuca owes wages to the person with that Social Security number. And the law is pretty clear. I know that they cite a case that deals with banking law. That bank case that they cite would have been completely different if the judgment creditor had identified an account number. We gave them the equivalent of an account number. We gave them a Social Security number. We think that that Social Security number matches the judgment debtor, and it's one of their employees. Therefore, based on the information they provided, they fall within 11.17, and that means that they may be required to attend before the court or judge and or a referee appointed by the court or judge and be examined on oath respecting the same. So instead of getting an order of exam on a judgment debtor, we could actually get an order of exam on Melaleuca, bring him to the courtroom, put him on the stand, and ask all these questions under 11.717. What would I ask them? Who is the employee with this Social Security number? What is their name? Do you have anybody there with a name closely resembling what is that person's Social Security number? I could do this under this code section. Absolutely clear. And they don't even make an argument saying that we couldn't. Except what they said was, because we didn't follow the procedure in 11.720 through 11.723, we now can't do it. That's not the case.
So what you're saying is that I can give them the relief they're requesting to the extent that they cannot be liable for forgiveness, but that you have the right to examine them about what money they have.
Okay, what I'm saying is I don't care if you do that. What I'm saying is they just made a motion to quash. You can't come in preemptively and say, we want the judge to rule and say we're immune from fault on that garnishment. If you want to do that, I don't care. It doesn't matter to me.
Well, they're also asking that they be discharged from any liability.
Yeah, but it would be on that writ, right? I can go get another writ and serve it. So if the court wants to discharge them from liability on that writ, I don't care. And the reason we kept saying, well, we haven't yet, is because we haven't yet. But we're not. But if we get the right Social Security number matched to Huerta and we find out, and it may also be the case. I don't care if the court discharges them, but it may very well be the case that this name might be spelled wrong. They are very, very wordsmithy when they talk about these things. Very careful. We don't have anybody with the name exactly. We're going to get to the bottom of this, and we're going to find out that the is going to be very, very close. It's going to be the same Social Security number. They're going to know who it is, and I don't know why really they make such a big deal out of it.
Maybe because their employee with Social Security is named Sarah Smith.
But we're not going to know until we take the deposition or we do this procedure. So let me get to that. So what we're trying to seek in this case is I'm not so interested in pursuing them on the writ that we sent out. But what I need is I need to either employ 11.17, and it says I get to do that, and I would do it just like a writ of execution or an order of examination. Instead of serving on the debtor, I'd serve it on these guys. And then we would come here and we would do it. But given that that statute was enacted in 1881, we actually have another way to do it that's not so cumbersome, doesn't involve the court, and that is a deposition. So under Rule 26, discovery, general provisions governing discovery. It says parties may obtain discovery regarding any non-privileged matter, including the... So I'll give the court a chance to get there. It's 26...
Go ahead.
26B1A, you get to conduct discovery to determine the identity and location of persons who know any discoverable matter. So this is why we sent, it's a 30B6, it was mischaracterized as 60, just a typo, but a 30B6 asking them to designate the person, and we said, here's what we want. We want the person or persons most knowledgeable about Bryan Huerta, in quotes, meaning whoever that person is, with this Social Security number. Now, I'll tell the court under Rule 30, depositions, under Rule 30, A1, without leave. We don't have to come to the court and ask for permission, like we do on a supplemental exam for a non-party. A party may, by oral question, depose any person, including a party without leave, blah, 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 blah. And you can also do a non-party. So here we are, okay? I'm not seeking liability under that initial, at this point I'm not, and I don't plan to. Now, if I find out that they're just playing games with us, we may evaluate our options. They know who this person's name is, and they could tell it to us. And they could say, oh, but that's confidential. Really, with all these guys, they can't give me a stipulated protective order from the court? We could do that. What we're going to find out is, I believe, is the judgment debtor is the same Bryan Huerta that works for them with the matching Social Security number. I don't know why they're making such a big deal out of this. I don't understand. It may be because my office sent out the wrong letter under this other code section where people don't respond. Maybe they think that's what it is. But the point is this.
Maybe it doesn't appear to them that their employee is the same person and that they're using their employee's Social Security number, and they don't want their employee to be subjected to these actions of someone who may have already taken her identity.
It's all rank speculation. We don't know, but we're going to get to the bottom of it. So instead of coming to my office for a deposition for an hour with two guys against one guy, we come to a court, file multiple pages, thousands of dollars in effort. Instead of just coming to the office, doing it under oath, we can make the whole deposition stipulated and confidential. We could do that. So I wouldn't use it for anything else except this case. There's ways to do this. I do not understand why we're doing all this.
Well, Mr. Smith, of all people, you understand people wanting to stand on their legal rights no matter what the cost.
Oh, I know. That's why we're all equal under the law, and what the law says under 11.717, if they prefer, if the court prefers, we will do an examination in the court under oath, just like we do a supplemental exam on the bench of somebody from Melaleuca. We clearly have that right. Or we'll do it at my office. What they want to say is, nope, we want to be discharged from liability. We don't want to do it in the courtroom. We don't want you to depose this person. And the reason for that is, this is too expensive, too difficult, too duplicative. You could go ask it from her, which we already have. That's the name we got. And so right now, our best option to get this resolved is to have Melaleuca just tell us, well, who is got somebody there in quotes, so it's kind of like that. And you do acknowledge you have an employee with a Social Security number, just tell us who that is. And then what we'll do is we'll send our, if it is, for example, the Social Security number turns out to be a whatever her name is, then we can make an evaluation on how to proceed. They said that creditors are supposed to know the names of the debtors. Yeah, we are. But probably doesn't come as a shock to the court that debtors play play fast and loose with their names. Happens all the time. So we do the very best we can. I'm now trying to get that information. The debtor hasn't given it to us. We have reason to believe that we're not going to get the accurate name. But with a matching Social Security number, that's almost like a DNA match. We've got somebody, unless there's been identity theft. And if they tell us that, we figure out who it is, then we can move on. So that's why we're asking the court.
How do you know, say there's a Sarah Smith working at Melaleuca with the same Social Security number that you're seeking, how then do you know whether or not she's your judgment creditor?
Okay, so part of it
If
is...
somebody is using a Social Security number falsely to obtain credit.
So here's how that works. It's easy to do. That's a different issue than how Melaleuca extricates itself from this problem that's been created. So if we determine that, and we have ways to look, we have medical records, we have descriptions of what the person looks like, we have a Social Security number. If we have a Social Security number that matches our person and their person, and the person is described as a 5'4" female with blonde hair, and the medical record, that we get information from that. Our process servers also serve them, so we know what they look like. But the key here is how to get Melaleuca's concerns solved, and the way to do that is let us get the exact information that we need, so they don't have any heartburn over this. Then their hands are tied. If we say, let's suppose the name turns out to be like Sally Smith with this Social Security number, and we determine that is Sally Smith, then what happens is we'll send out a garnishment saying, Sally Smith with this Social Security number, they're going to go, bingo. And whether it's right or not, that becomes our problem, but then they're absolved and they're off the hook. Then what happens is that we take their money. If they don't think it's them, then they can file a claim of exemption and say, hey, that's not me. But if it is them, and they know that they've changed their name or they've stolen identity or whatever the issue is, they then get to choose. They're in control. The real issue today is Melaleuca is saying, you've got a matching Social Security number. We don't have somebody by the name of quotation marks, which means it's probably close to that. So we're not going to comply. Okay, just tell me what it is. Well, we can't tell you. Okay, let's do a deposition. No, we're not going to do that. Well, we want you to do it another way with interrogatories or with something else. We just want to do the deposition. There may need to be follow-up questions. I anticipate it'll be very, very short, much shorter than today's hearing. So for those reasons, Your Honor, it's not oppressive. It's not overly burdensome. We clearly have a right to obtain this information from a discoverable source. They've got it. We can't get it from her. We've gotten the best we've gotten. And so we'd ask the court to either let us do our deposition in my office, and again, if they're concerned about confidentiality, we'll make the whole deposition, stipulate it to be confidential. You can even sign a court order so we don't disclose it to anybody. Or let's bring him in here so I can get him under oath to ask questions about who this is in relation to the Social Security number. And then we'll be done. And then we'll send out another garnishment, and the first garnishment is just water under the bridge. Unless the court has any questions for me.
It still just seems to me that you're getting the cart before the horse. I mean, even under 11.717, you assume that this is their employee. It says any person owing debts to this judgment debtor may essentially be examined. And so you're assuming that they do have that money.
Your Honor, they have told us we have a Social Security number for the judgment debtor.
Right.
Okay? They have told us they have an employee with that Social Security number. I don't care what the person's name is. Just call it John Doe or Jane Doe. Doesn't matter. With a matching Social Security number means they're paying an employee, and we have a Social Security number that says, hey, our judgment debtor's got this number. That gets me easily past a Rule 11 allegation. Easily we're acting in good faith. So would they be. And so the point is I'm not assuming it. I'm doing it based on what they told me. And the code section says that we get to any person owing debts to the judgment debtor. Since we have a Social Security number for our judgment debtor that matches one of their employees, there's no dispute about that. It thus appears that, in fact, Melaleuca does have money in his possession owed to the judgment debtor. The only thing we're fighting over is the technicality of what is the person's name. That's what I'm trying to get to. So we're not stepping out on a limb whatsoever by this.
Although you admit that lots of people use false Social Security
No.
numbers belonging to other people.
No, we've seen it-
It's not uncommon in your business to have Social Security numbers used by two people or different people or the wrong people.
So here's what we see. We do see different, we will see, for example, two Social Security numbers being used by one person. But what we see 100 to 1 to that is people changing their names. So, in terms of Social Security, the court seems to be fixed on, well, maybe the Social Security's wrong, number's wrong. All the information we have is that that's the right Social Security number. The information that we've got is she's using a different name. So, if we would have sent our garnishment and just said, we want to garnish the wages of the employee with this Social Security number, I'll bet you they would have responded. We said, we're not even sure what her name is. This is the Social Security number of the judgment debtor. This is what we want. They may have very well responded. So the point is that we do have not just a good faith basis. We've got an admission from Melaleuca that the Social Security number for our judgment debtor is somebody that works for them. All we're fighting over now is the technical way to tell them what the person's name is that they're using today. The only ones that really have that, well, the judgment debtor has, but they haven't been truthful so far giving it to us, forthcoming, I should say, is Melaleuca. They've got it. If they just tell us what the magic words are, then we would say, okay, we want this Social Security number for this person. You told us who it is. Those match. If that person turns out not to be the right one, they can file a claim of exemption. And if we get it wrong, there's statutes that protect them, and they can get attorney's fees and whatever it is, and there's liability for us. That's where the issue is.
All right, thank you. Mr. Long?
Your Honor, I'd just like to address a couple of points. First, Melaleuca has already invited plaintiff to propose a simple solution, and when Melaleuca proposed that, frankly, opposing counsel laughed at Melaleuca and was not interested in proposing a simple solution that seems to be suggested here today. Moreover, opposing counsel makes clear that if they think Melaleuca has been playing games here, they're going to pursue Melaleuca for liability. And under the statute, as I explained, Melaleuca simply can't be liable for the underlying debt here. So we're still amenable to a solution short of a notice of deposition and a subpoena. However,
what is the solution you are proposing?
if they sent us a simple single interrogatory that simply asked what the name of our employee was with the social, we would respond to that as long as we're going to be discharged from liability first, like the statute says. Your Honor, there's also like to correct the record as to what...
So, Mr. Smith, you don't like the idea of sending them an interrogatory saying what is the name of the employee who has a Social Security number?
Two things. One is, if we do that, they can be hyper-technical and not give us exactly what we need. So a couple of follow-up questions might be helpful. And so in practice of law, in 30 years, very good trial attorneys never send out written depositions to third parties because they're like interrogatories. Unless you can sit there and ask follow-up questions, you really don't get good information. Secondly, did you hear what he just said? We'll give you an interrogatory, provided you release us from liability. Your Honor, the court ought to, at this point, be wondering, well, why are they so worried about liability? I think there's something very technical going on. We haven't sought liability, but we also, this isn't the proceeding today to decide that.
So you think Melaleuca is afraid of the liability of what, $1,000 or $2,000?
I think that they'd be more concerned about being liable for anything and how that would look publicly than they do about money. They obviously don't care about money, but if they wrongfully withheld the garnishment and that were to be litigated or determined, that might be a big problem for them. And I'm not interested in embarrassing anybody or doing anything like that. I want to just get my garnishment done, but he's just said it. We'll give them an interrogatory if they agree to discharge us from liability. But we don't have to do that because we didn't even seek the procedure for them to get discharged from liability because we never sought to litigate liability.
Your Honor, I'd like to address...
And this is not the procedure today on a motion to quash to even address the issue.
Your Honor, I'd like to address that exact issue. Reading Idaho Code 11722, there is no requirement that any exemption proceedings or any exception proceedings or any denial proceedings have taken place. There's simply no requirement that the judgment creditor first move to exempt or accept or otherwise deny the garnishment answer before that statute applies. If they miss the 3-day window, Your Honor, the consequence is that Melaleuca's garnishment answer is true and sufficient. Moreover, the consequence is that Melaleuca must be discharged from liability. That is simply the case. And Your Honor, to say that the general discovery statutes somehow permit an end run around the garnishment statute is simply incorrect. Even though the legislature passed this statute more than 100 years ago, it could have been changed last year, like counsel mentioned, but it wasn't, and the consequence is Melaleuca must be discharged from liability in this case. Thank you.
If the court has any lingering questions over this that you would want me to respond to, I will tell the court that there has been no case brought before this court challenging the sufficiency of what they did in that writ. Therefore, there is no procedure. All they've filed is a motion for protective order in which they seek to prevent us from doing the deposition and throw in, and we'd like to be discharged from liability. Under what? 11-722? There's been no procedure filed under 11-721
again, Your Honor,
that would allow that.
There is no requirement.
Only one person at a time.
Excuse me, Your Honor. There's simply no requirement under the statute that they have to first bring proceedings. That simply is not found in the language, and we can read it all day long if we want to.
Stop, Mr. Smith. Don't interrupt.
Okay.
Mr. Law either. I've heard plenty from both.
Okay.
Thank you, Your Honor.
All right, here's what I'm going to do. Well, it's tempting just to entirely grant Melaleuca's motion and then let the parties appeal and duke it out in district court. I'm going to try and craft a solution that I think both abides by the law and resolves the dispute so that nobody has to incur more costs. I'm looking at page 2 of the motion filed by Melaleuca on July 2nd. And I'm going to grant the motion as regards to paragraph 1 and paragraph 2, paragraph 4, I'm going to not rule on paragraph 5 at this point in time. Under paragraph 3, I'm going to enter an order requiring Melaleuca to answer an interrogatory from MRS that requests the name of the employee whose social security number is the one that has already been propounded. See, that's social security number ending in Any questions or clarifications about that, Mr. Freeze, or Mr. Law, excuse me?
No, Your Honor.
Mr. Zollinger?
Mr. Smith.
So,
I would ask the court to state its grounds for denying us our ability to take a deposition. What are the specific grounds that that motion was granted?
I'm relying on the grounds stated in the motion filed by Melaleuca.
Okay, thank you, Your Honor.
Your Honor, if I could ask a clarifying question of the court.
Sure.
Is it just the one interrogatory that the court's ordering us to answer? I just want to be clear so we're not...
Yes.
Just one interrogatory.
And I think that under 722, Melaleuca's arguments are all accurate. I think it's also probably true that Mr. Smith, it would be helpful if your names weren't both Bryan. That's the right last name. But I think Mr. Smith is probably also correct that even if I grant you this relief, he can come back in under 32-717 if he believes that you have,
11717.
sorry, 11717. What did I say?
32.
We
Thank
understand,
you.
Your Honor. I just want to clarify the numbers in interrogatory you're allowing.
Yes.
And Your Honor, just to be clear, are you saying that we are unable as judgment creditors to pursue our rights under 11717 and only are allowed to send an interrogatory to Melaleuca?
I am saying that under 11722, you did not properly file the 3-day notice of objection after they'd filed their response, but that under 11717, if you believe, or if you can show, I guess, I should say, that they owe debts to whose social security number is whatever was propounded.
The judgment debtor.
Yes, that that you may still be able to get discovery from them. Like you said, you know, we can respond to this writ and you can send another writ saying, you know, garnish the paycheck of the person whose social security number is this. That question's not before me, so I'm not sure that you can do that. You argue that you can do that. No, you may have other things to say about that,
yeah,
but that's not my question. I still believe that you may have the cart before the horse, and that you may have to prove that they actually owe debts to your judgment creditor, not just an employee with that social security number, before you can actually engage in further discovery. That's why I'm limiting the discovery to you asking them what is the name of their employee with the social security number.
And that's my question. Are you saying that's all we can do? We do not, if I don't want to do that for various reasons, if I want, because I think that that's not what I want to do. As a plaintiff,
Because you want to stand on your legal rights?
Well, we get, the plaintiff, that's the great thing about a plaintiff. A plaintiff gets to choose how to litigate his case. And I really appreciate counsel telling us, well, here's what we're willing to do and not willing to do. But the law really controls what a person does. So I just want to make sure that if I appreciate the court saying this is what you're going to do in terms of the motion to quash, you're saying we can't do a deposition, but we are allowed to do an interrogatory, which we always
Which I
have to.
have authority to do under the rules to limit discovery, correct? And
That's
that's what
correct.
I'm doing under the rules, is limiting discovery to avoid
And
cumulative
that's-
cost to any
That's
of
why
the
I'm
litigants.
trying to clarify this, because Rule 11717 is not a discovery tool. It is
No, it's not.
So I'm wondering, and so I just want to know, if I decide I want to pursue that, instead of, or in lieu of, or both of them, if I want to do that instead of sending an interrogatory, which I now can do, I'm going to
My
hear
order
from...
will prevent that.
Okay, so my question is what is it that they never even made a motion that we couldn't seek not discovery. All they're trying to do is stop discovery. We now, if we want to do an order of examination of Melaleuca under 11717, which is a writ procedure, it's an examination procedure, is the court saying that we can't do that either?
Mr. Law?
Melaleuca's position would be that no, they cannot. As the statute says, it has to be the case that Melaleuca owes money or property, and by operation of 11722, it's true and sufficient that Melaleuca does not owe money and property to the named judgment debtor. So that's simply not a tool that's available to them any longer.
Your Honor.
I understand you disagree with that analysis, but that is the same analysis as mine. That they've denied that they have this money.
No, they haven't.
Okay, they've made an objection to the writ that you issued, the writ of garnishment. They've made an objection and said, we don't have a person with this name employed by us.
Correct.
You did not object to that. And
I
that's,
don't have to.
well, I understand you say that, but I'm disagreeing with you and agreeing with Melaleuca that you do in order to
In order to do
Further-
discovery?
in order to further proceed.
Wow. Would the court please identify one statute or rule that says that we cannot proceed unless we file an exception under this rule? Because I'll tell the court, I know I'm aware of nothing in the code section that says that. Under 11.722, there's nothing in there that says that we can't proceed with discovery if we didn't invoke that exemption, that writ procedure. Nothing. And there's nothing in it that says that if we don't do that, then we're then precluded under 11.17 from bringing them into court to get additional information.
Is there anything unclear about my ruling?
Yes.
Mr. Smith, I've granted their motion, paragraph 1, 2, 4, I'm withholding 5, and I'm granting it in 3 to the extent that they have a protective order saying that you cannot pursue further discovery except to send them an interrogatory saying, what is the name of your employee with this social security number?
The only thing that's left unclear is we haven't conducted any discovery, so it's not a further discovery or more discovery. The court has bought into their argument
All right, then
that
I
all
will
that's
say
discovery.
you can engage in discovery to the extent of one interrogatory that says what is the name of the employee whose social security
And
number
I understand that, and I accept that order. What I still do not understand is, under 11.717, that is an examination procedure before the court. Is the court saying that the court's orders brought it up that we can't even do that?
That is what I'm saying, because I'm agreeing with their argument.
Okay, and that's the only part I'm left unclear. I'm not trying to be difficult. What is the basis in law to say, because we did not accept under 11.722, we're now precluded from proceeding under 11.717? That's all I'm asking for.
As I am not a witness on the stand, I am not going to answer that. I think I've fully explained my decision.
Perhaps opposing counsel can say what their basis is, because I haven't heard any offered today.
I think it's clearly explained in their briefs. Mr. Law, anything else?
No, Your Honor.
I'm going to ask you to prepare the order. Is there any clarification you need before you can draft such an order?
No, Your Honor.
When can you have it to me?
Later today, Your Honor.
All right, I will expect that.
Thank you.
Maybe excuse Your
Once
Honor.
again, I thank both parties for bringing at least an interesting legal issue before me, which is rare enough in this position.
Thank you, Your Honor.
We'll be in recess.